Hi, I'm David Doorey, and this is the Law of Work mini lecture series in which we're considering chapters from my new book, The Law of Work. This lecture considers Chapter 12, Summary Dismissal, Termination for Cause Without Notice.
I'm going to get right to the point. It's come to my attention that you and the cleaning woman have engaged in sexual intercourse on the desk in your office. Is that correct? Who said that? She did. Was that wrong? Should I not have done that? I tell you, I gotta plead ignorance on this thing, because if anyone had said anything to me at all when I first started here that sort of thing was frowned upon, because I've worked in a lot of offices, and I tell you, people do that all the time. You're fired. Well, you didn't have to say it like that. I want you out of here by the end of the day. What about the whole Christmas spirit thing? Any flexibility there? Nah.
Hi, welcome back. Okay, let's begin our discussion of summary dismissal by considering a basic rule of the law of termination of employment contracts in Canada. The general rule is that a non-union employer can dismiss an employee for any reason it likes, or no reason at all, provided that it gives the employee reasonable notice of termination. But there's two exceptions to this general rule. The first exception is if there is a legally enforceable notice of termination clause in the contract. This is something we discussed in Chapter 8 of the textbook. And the second exception is if the employee has committed a very serious breach of the employment contract. And this is known as summary dismissal, which is the subject of the chapter we're considering now. So the question we consider in this chapter is, when has an employee's breach of contract risen to the level that he or she has forfeited his or her entitlement to receive notice of termination? And we'll begin that discussion by considering a few general or basic principles before we turn to the various types of employee behavior that can give rise to summary dismissal disputes. A first point to note is that summary dismissal is considered to be the capital punishment of employment law. Because the implications are so drastic for employees, modern-day judges have required employers to meet a fairly stringent test to justify termination without notice. This approach is exemplified in the leading case on summary dismissal, which is called McKinley versus BC Tel. The case falls within the general subject of termination for dishonesty. But the test that the court applies is relevant to all summary dismissal cases. So make sure you read the case carefully and think about the test that the court applies in the case. Briefly, McKinley gets sick from high blood pressure and he needs to take some time off. And his doctor tells him that he can return to his old job if he takes a drug called a beta blocker, or he can request that the employer provide him with a less stressful job. And McKinley tells the employer that he needs a less stressful job, but he leaves out the part about being able to return to work to his original job if he takes the beta blocker drugs. And the employer says they don't have any alternative job, and they end up terminating McKinley. And at the trial, the employer argues that it didn't need to provide McKinley with any notice because he was dishonest with the employer in not disclosing that the doctor had said he could return to his old job if he took the beta blocker. And the employer argues in the case that any dishonesty by an employee is grounds for summary dismissal because trust and confidence in the employee is central to the employment relationship. But the Supreme Court of Canada rejects that line of argument. It says that the rule in summary dismissal cases is the principle of proportionality. Courts must consider all of the facts and then decide whether the employee deserves to forfeit their notice entitlement. There has to be proportionality between the crime and the punishment. So in the McKinley case, the Supreme Court of Canada says that not all dishonesty by an employee is grounds for summary dismissal. In that case, the court said that McKinley was perhaps not entirely forthright with the employer, but this did not rise to the level of dishonesty giving rise to cause for summary dismissal. And therefore, the employer should have provided McKinley with reasonable notice when it terminated him. And the court ruled in this case that the notice period was a very lengthy 26 months. Okay, so the first general principle of summary dismissal is the principle of proportionality. Courts consider all of the facts and they decide if the employee's behavior is serious enough to warrant summary dismissal. A second general principle is that summary dismissal can be based on a single, very serious wrongful act by the employee, or on cumulative just cause. When I say a serious or deliberate act, I mean an act that the court believes standing alone has completely destroyed the relationship of trust between employer and an employee. In other words, it's irreparably destroyed the employment relationship. So that takes something very serious. Cumulative just cause involves a situation in which the employee has been given multiple warnings and yet has failed to correct their problems. Cumulative just cause requires something called a culminating incident, a final wrongful act, or the proverbial straw that breaks the camel's back. An employer relying on cumulative just cause is expected to have warned the employee that if they don't improve, they could be terminated. Okay, so an employer can rely upon a single very serious wrongful act or cumulative just cause to justify summary dismissal. A third general principle is that an employer who waits a long time to take action against an employee for a wrongful behavior may be found to have condoned the behavior, which means that a court will not permit the employer to rely on the misconduct as the basis for arguing cause for summary dismissal. There's no fixed rule for how long an employer can wait before they will be found to have condoned the misconduct. Courts just look at all of the circumstances and decide what's a reasonable amount of time for the employer to discipline or terminate the employee for their misconduct. Okay, a fourth general principle is that employers can rely on evidence they discover after they have already terminated the employee. The legal question in summary dismissal cases is whether the employee's behavior warranted summary dismissal, and the fact that the employer learns about the misconduct after it has already terminated the employee doesn't change that calculus. Otherwise, an employee could benefit from concealing his or her wrongful behavior from the employer. This fourth general principle, that employers can rely on information it learns after it has terminated the employee, encourages employers to keep investigating the employee right up to the trial. And finally, a general fifth principle is that a contract that includes a specific penalty clause may override a judge's discretion in deciding if there is grounds for summary dismissal. For example, a contract might have a clause that says that theft is grounds for immediate dismissal without notice. In that case, the court could be bound by the contract, meaning that it would have to find that the theft was grounds for summary dismissal. Okay, that's our discussion of the general principles that are applied by courts in summary dismissal cases. Before moving on, let's quickly summarize how courts approach these summary dismissal cases. First, the courts ask whether the employer has established that the employee breached some term of the contract. And in this regard, those implied terms we looked at in Chapter 9 become important. And you might want to refresh your memory of what those terms were. And in applying this first step, the courts ask whether the employer established on a balance of probabilities that the employee breached the contract. That basically means in plain language that it's more probable than not that the employee did what the employer is accusing the employee of doing. And if the court finds that the employee did do something wrong, did breach the contract in some way, then it moves to step 2, in which it asks whether the employee's misconduct was sufficiently serious that it undermined the employment contract. And here the courts consider all of the facts, including what are called mitigating factors. And these can include the employee's length of service and their past record, whether the act was premeditated or provoked, and it could even include the employee's personal circumstances, such as whether they have children or whether they're looking after elderly parents. All of these things are thrown into a mix, and the courts then step back and they ask, when you consider everything, did the employee's conduct warrant termination without notice. Remember to keep in mind what's happening in these cases. The employer has terminated the employee for some type of misconduct, and the employee has sued the employer for wrongful dismissal, which, as you know, means that the employee is arguing that their contract was terminated without proper notice. And the employer is arguing in its defense that it's not required to give notice because of the employee's wrongful conduct. And so the court has to decide in these cases whether the wrongful conduct rises to the level that would allow an employer to fire the employee without notice. The remainder of the chapter in this lecture reviews some common types of employee misconduct that have given rise to summary dismissal lawsuits in Canada. There are other grounds that I don't specifically discuss in the chapter. For example, I don't have a section on termination for having sex at work, which is what got George fired in the opening clip from the show Seinfeld, which is actually a good question. Would George's employer have had grounds for summary dismissal if George was in Canada? I'll leave that question with you to think about. Okay, what I want to do in the remainder of this lecture is just quickly walk through some of the cases and make a few points for you to think about as you read the chapter. And you'll probably be happy to know that I'm not going to spend a lot of time on each of the cases, so this lecture doesn't drag on too long. Nice. Okay, so the first grounds of termination that comes up in the book is dishonesty and conflict of interest. And we've already dealt with this when we looked at the case of McKinley versus BC Tel. And if you recall, we learned in that case that dishonesty is serious. However, not all dishonesty is serious enough for the court to treat it as grounds for summary dismissal. And so the courts will look at all of the circumstances, such as whether the dishonesty was premeditated, the level of dishonesty involved, how long the person's been there, their past record, and all of those other mitigative factors. And the court will decide whether this dishonesty was serious enough to warrant summary dismissal. Recall from Chapter 9 that there's an implied term in employment contracts that employees will perform their jobs competently and safely. However, considering what we've learned about the proportionality test, it should come as no surprise that not every incident of poor performance or unsafe work is grounds for summary dismissal. The court is looking for something more along the lines of spectacular incompetence, or what the courts call gross incompetence. This is incompetence that rises above the level of what you would expect from an average employee. It's possible that a single act of gross incompetence, especially if it involves safety concerns, can rise to the level of summary dismissal. An example is provided in the case called Bowser versus Federated Cooperatives in the textbook. In that case, the employee negligently released some 50,000 liters of poisonous propane into the environment. And instead of reporting it to authorities or to the employer, he went home and had lunch. But more commonly, employers try to rely upon cumulative just cause in incompetence cases. And this involves giving the employee a series of progressively more serious warnings and a fair chance to improve. The case called Babcock versus CNR Weikart is such a case. Pay attention to the reasons why the employer loses that case. What should the employer have done differently? Recall from Chapter 9 that there's an implied term that employees will obey lawful directions from the employer, and a refusal to obey such an order is known as insubordination. Insolence is insubordination with an attitude. So insubordination is no, I'm not doing that. And insolence is, no, I'm not doing that, you stupid loser. Both types of behavior are a breach of contract. But as we know, not every breach of contract is grounds for summary dismissal. Proportionality applies. An example is provided in the case of Henry versus Foxco, which involves an employee getting angry at his supervisor for telling him to speed up. And he yells, "If you want to fire me, go ahead." So the employer fires him. Did the employee's insolence and insubordination in that case amount to grounds for summary dismissal? See what the court says and pay attention to the test it applies. Okay, there's also an implied term that employees won't harass customers or coworkers. And harassment is serious, especially if it's based on human rights grounds such as gender, race, religion, and so forth. Employers are required to take steps to eliminate harassment, and often that step is to terminate an alleged harasser. But is every incident of harassment grounds for summary dismissal? Well, you should know the answer to that by now. The answer is, it depends. How serious was it? Was it a one-time spontaneous event, or was there a pattern of misbehavior? Was there provocation? Was it clear that the harassment was unwanted? Or is it possible that there was back and forth playful banter? Was the harasser in a position of authority over the victim? Was an apology offered? All of these factors are relevant to the assessment of the court of whether harassment or violence in the workplace constitutes grounds for summary dismissal. There's a case in the text called Warkins versus Marriott Hotels, which is an example of a case involving a manager harassing a subordinate outside of regular working hours. How does the court deal with those facts? Next, consider off-duty conduct by an employee. Can what an employee does when he or she is not at work be grounds for dismissal without notice? Usually what employees do on their free time is none of the employer's business. But there's an exception to that general rule. If the employee's conduct harms the employer's economic interests, then it may violate the implied term requiring that employees act in a manner that advances the employer's economic interest, which we discussed in Chapter 9. The case Kelly versus Linemere Corp. provides an example of how courts deal with off-duty conduct by employees. Kelly's misconduct involved an arrest for child pornography on his home computer. Pay attention to why the court finds that this did constitute grounds for summary dismissal, even though Kelly was, by all accounts, a good employee and the behavior in question did not take place in the workplace. Do you think it would make a difference if Kelly was a forklift driver in Toronto, for example? Also, think about how the court's application of summary dismissal law would apply to an employee who says, for example, negative things about the employer's business on social media. This is an important and growing area of the summary dismissal law involving off-duty conduct. Okay, by now you should have a pretty good sense of how courts deal with these in summary dismissal cases. First, they ask whether the employee has violated some expressed or implied term of the employment contract. And if the answer is yes, the courts then consider whether the behavior is serious enough to justify summary dismissal without notice. And I've included a variety of other grounds in the textbook. For example, intoxication is a violation of the implied term in the employment contract that employees will report to work sober. Absenteeism is a violation of the implied term that employees will be punctual and show up for their scheduled shifts. And I note in the textbook that both of those grounds, intoxication and absenteeism, may give rise to human rights grounds if the reason for the absenteeism, for example, is due to disability or, say, religion, or if the worker involved has a drug addiction or an alcohol addiction. Then issues may arise within the regulatory regime and human rights legislation that require the employee to accommodate the employee. And we'll learn about that when we get to the regulatory regime later on. But if we assume that the employee is not alcohol or drug addicted and they just miss work for some other reason, or they show up to work intoxicated, then that's a breach of their employment contract. And again, the courts will assess all of the circumstances and decide whether the employee has forfeited his or her right to receive notice. Misuse of employer technology, such as using the employer computer to surf the web or be on Facebook, or view pornography or distribute pornography to coworkers. All of those things can violate various terms of the employment contract. It goes without saying that an employee at work should be doing their job and not surfing the web. And so the law treats misuse of employer technology as time theft. and if an employee is distributing, say, pornographic images to coworkers on a company computer, then that might also be harassment. Okay, so all of the cases are dealt with in a similar way, and I'm not going to go through those cases in any detail. You can read the textbook. And you should come away with this chapter having a very good sense of how courts deal with summary dismissal cases and understanding the proportionality test. Okay, that's it for Chapter 12 on summary dismissal. Until next time, I'm David Doorey.